He is the recipient of the American Antitrust Institute's Alfred E. Kahn Award for Antitrust Achievement, the ABA section of Antitrust Law 50th Anniversary Publications Award, the Federal Trade Commission Award for Distinguished Service, and the Donald H. Gordon Award for Excellence in Teaching at Wayne Law. Professor Calkins originally started at Wayne Law in the 1980s. He has taken several multi-year absences to, among many other things, serve as General Counsel for the Federal Trade Commission. He lived in Dublin for 4 years with his wife, serving as a member of the Competition Authority of Ireland, which is essentially the FTC of Ireland. And he's done several stints as visiting professor at various law schools. On a personal note, in addition to singing in Gaelic, Professor Calkins is also a great supporter of Detroit and all it has to offer. He's often found on group bike rides or giving bike tours of Detroit. But he is also the creator of a program to get our students, law students, involved in enjoying many of the things that the city of Detroit has to offer. And one of them are sound cards, so that students, Professor Calkins has paid for sound cards so that students can attend Detroit Symphony Orchestra concerts for $5 per concert. And the hope is that these students then go on and become lifelong members of the symphony, preferably here in Detroit. So without anything more, I will present Professor Calkins.
Thank you, Rob. And thank you for mentioning the sound card program, which you can all read about in the most recent Wayne Lawyer, where my dog and I are in there signing up students for it. It's actually a better program than Rob mentioned. He got tripped up. The students can bring a friend at $5 a head, but the students are free. They get to go to 120 different concerts down to Orchestra Hall, classical and jazz and pops and children's, all for free the whole season long. So it's a terrific program, and a number of students have gone down and learned that Detroit really is a great place, and that Wayne State has lots of things that, for instance, Michigan and Michigan State do not have. We're always trying to promote the city and promote the law school. And that's part of what this program is about. And so I thank you for the opportunity to talk. Antitrust has become a fashionable and a hot subject and all that sort of stuff. Indeed, last fall, I spoke at the Eastern Regional Meeting of Attorneys General of the states, giving them a whole course in 60 minutes. And it was such a hit that I was brought back last June in Chicago for the National Meeting of Attorneys General to give a whole course. This time it had to be in 30 minutes. But then the Attorney General of New York asked me questions for a half hour, and that was just immense fun. I also spoke, as I have a couple of times, at a training session for federal judges, and the topic was the future of antitrust. And so when Rob asked whether there was a talk that might be of interest to alums and friends of the law school, I said, well, you know, lots of people are interested in antitrust these days and the future of it. Would you like me to talk about that? And so this then is a revised version of that talk. It's also cribbing from an article that I'd published in the Antitrust magazine, sort of right towards the beginning of the Biden administration. And all I have to do is just read the article, but I won't bore you with that. Instead, we'll go on and answer the questions that the judges had, and that you probably have two simple questions, but it'll take us a fair amount of time to work our way through it. We'll go along briskly and then see if there's time for how many questions at the end. Two simple topics: how different is it, and how much of this will last? So we start with a difference. It really, I mean, I've been teaching here, as Rob noted, for a long time, and this is an unusual time with antitrust in the headlines again and again and again and again. I mean, right now, there was just the New York Times Sunday magazine, I should have brought it in, had the most important people in college football, and there was Jeff Kessler, the plaintiff's lawyer, who has brought many of the cases on the name, image, and likeness. Anybody who cares about any kind of college football knows that the world is totally different because of antitrust. Real estate commissions, you know, the 6% commission, that is now under assault because of litigation that has been kicking around for probably 20, 30 years, finally reached a big settlement, and the rules have fundamentally changed because of antitrust. What else do we have? Epic v. Apple. There's one where the App Store has been opened up because of actions already taken in that litigation. I should have mentioned there the Justice Department recently sued Apple, and so we got more litigation going with Apple. Google, you know, constant news about Google. Heck, in today's Wall Street Journal, we had an article that Google faces another lawsuit. There are two Justice Department lawsuits. One has come in with an answer. The second one begins today. And so the headlines are continuing right now. That's just proving you that I updated these slides as of today. But beyond the Justice Department cases, there have been state class actions, big settlements. It's been a big headline. MasterCard and Visa have agreed to settlements to start changing their rules for that incredible fees that they charge when you're using one of them. There's been settlements with class action suits against elite colleges on financial aid, big awards in meat, big awards in generic drugs. Non-compete clauses became a really big deal actually when the states, mainly the state of Washington, began challenging non-compete clauses in McDonald's and Burger King and all of the franchise operations, and they entered into settlements eliminating non-compete clauses with, I don't know, 100 different franchising operations. And now the Federal Trade Commission has tried to enter a rule about that, more of that later. And then finally, you know, antitrust has been in the presidential campaign where we have, it's not clear if this is antitrust, but it's clearly about sort of something having to do with high prices. With Vice President Harris going after price gouging, whatever that is. She's opposed to it. We get news that J.D. Vance is down on mergers a little bit, and so don't expect smooth sailing for sort of big company mergers if they get elected. So we've got we're in the news. The other thing is that the climate is very different. And I use the word climate deliberately because that's what it is. You know, just like you feel warmer sometimes, well, we got global warming going on. We've got a warming of issues related to antitrust. Both parties complain about big tech. Republicans say big tech is out to get it, and the Democrats say big tech is too damn powerful. It's a bipartisan thing. Bipartisan, both parties complain about fees and high prices and things. The State of the Union address has talked about antitrust for the first time in several decades. It just doesn't make it into a State of the Union address, and there it was. Scholars are showing concern about things that, you know, were laid to rest and were not an issue for a while back. And the bottom line is that I think there is something of a pendulum change. Maybe not an inflection point, but things are certainly changing and going back to a different place. And then the last thing that's really different is the attitudes of the enforcers. And again, I use the word attitudes very deliberately. I put it in bold for you. because you can have an attitude, and then there's another question about what you actually do, and we'll look separately at that. But the attitude's very different. There's been lots and lots of talk from the Biden enforcers about mistakes made by previous administrations. Indeed, the Democrats who were on the Federal Trade Commission during the Trump era regularly bashed previous commissions that having been asleep at the switch and not doing the job. Much more talk. It used to be that each new leadership of an agency would say nice things about the agency and its history and how great it is and so on, but now much more focused on mistakes. Mergers. I literally was at a session where an incoming head of the Antitrust Division, this is a couple of administrations ago, came in and explained to the audience that their job was to, if a merger was reported to them, to study the merger, to think about it, to see if there were concerns, and if there were concerns, to work with the merging parties so that the problems could be remedied and the merger could go through, because they got up in the morning with a belief that mergers were fundamentally beneficial. And if you could fix a problem, you should help as a government agency fix the problem and let the merger go through. Nowadays, the Biden folks are very clear that if there are no mergers between now and the end of the administration, that's fine with them. They're not in the business of facilitating mergers. Remedies, they are very, very anxious about whether remedies can be effective. The Antitrust Division has almost said that they refuse ever to enter a consent decree because they're afraid the remedy won't be effective, and the FTC constantly talks about how they're nervous. I don't know, 20 years ago, 10 years ago, you had faith that if you just left the market alone, competition would break out because entry was generally easy and problems were self-correcting, and if you just leave things alone, the problem will go away. The only things that last are stupid government actions. Well, that attitude is now changed. There's much more faith in what the government can do and much less faith that the markets will self-correct. This is largely a function of the big tech, with people seeing the staying power that some of the big tech folks have had, and how once you're in there, it's hard for competition to break out. Private equity has become a fashion. Folks are very down on that in the agencies. On the other hand, they view themselves very much as promoting unions. Antitrust people used to view unions as like an exception or something where we allowed arrangement on prices grudgingly. Now unions are regarded as an absolute good for the antitrust people. Interlocking directorates where you share directors, that's a concern now. The whole government approach, Tim Wu came into office with Biden early on, and they said that every government agency ought to be thinking about competition issues and think about it not just in these two agencies, but also in transportation and in agriculture and so on. And then the FTC is working on rulemaking and broadening its mandate and talking about bringing price discrimination cases and doing a whole lot of talking about bringing more different innovative theories and actually bringing one rulemaking proceeding. So the attitudes are very different. And the final example of this you can see from the new Biden 2023 merger guidelines, which finally came out after quite a long gestation period. You don't have to look at this, but the point is that it's a very detailed screen where there are a whole lot of detailed guidelines. And that's just my little way of saying that the format is very different. These are very different guidelines in the look, in the feel, in the approach. All the guidelines before had been sort of documents that were for internal agency use without any footnotes, simply said, here's how we analyze mergers. These are much more rules that are set out trying to address the general public and not just internal, the general public and not just courts. And it's much more of a transparent effort to basically be an amicus brief to the court. There are lots of footnotes and quotes from cases which were never found in the old guidelines. So the format's very different and the focus is different. All of the modern era guidelines, 1982 to 2010, that starts with President Reagan, one of the key original sentences was that the unifying theme is that mergers should not be permitted, what? To create or enhance market power or facilitate its exercise. The or entrenches, because that got added at one point. But the key was merger enforcement is about market power. And it was not about anything else. It wasn't about First Amendment issues. It wasn't about diversity of views. It wasn't about small as a virtue all by itself. It was about market power. And the 2023 guidelines, totally different, a radical change, saying, no, we're concerned about structures and economic freedom and the free enterprise system. And our goals include the democratic, political, and social institutions. Big is bad for a whole variety of reasons. It's just a very, very different set of attitudes and concerns and interests. So you can see the difference right there. Now, when you go and do a word search in the guidelines, 2010 and the 2023, totally different kind of choice of words. The left column is the 2023, the right column is 2010, and basically that's sort of the standard where guidelines have been pretty much since 1982. Dominance, you can see huge focus of the Biden people. Entrenching power, big focus of the Biden folks. Worker, it wasn't in them at all, and now it's got 27 mentions. Trend towards concentration, wasn't anywhere. Now you get the idea. There are all sorts of things that are there that were not there before. And then down at the bottom, there are the flip side, things that used to be a focus of the guidelines before, detailed specific interests of kinds of harm that's much less the concern of the modern guidelines. You see the word coordinated used to be very much a focus. Will this merger allow for more coordination and in a specific way harm competition? Now it's much more, will firms be dominant, that kind of thing. So we've got a big, big change there, but let's go talk about where the rubber meets the road or something like that in terms of just how different is the enforcement that's actually taking place. So we start out with cartels. Price fixing is criminal. And for a long time, much of what antitrust was about was bringing global international cartel cases. I'd say around here, you've had massive numbers of auto parts companies have been indicted for the felony of price fixing on auto parts. And it's one where it's been a global thing involving foreign suppliers and domestic suppliers. And it's almost like the agency has just been going through the different suppliers, going after one and then another and another. Road building cartels all the time. Michigan has seen some indictments in road building too. Price fixing, actually, Michigan has seen some price fixing of hospitals with respect to nursing services. Sort of price fixing enforcement has historically been the key thing that the antitrust agencies do, in addition to mergers, perhaps. And cartel enforcement is way down in the Biden era. They've lost several of their major cartel cases. They've won very few. They don't seem to be bringing many new cases. There doesn't seem to be that many grand juries functioning. I say seem because they have stopped revealing data about what they're doing. It used to be that there was a web page on the Justice Department Antitrust Division site that showed detailed data for the number of grand juries and the number of indictments and the number of pleas and the number, everything of what's been going on. They've stopped sharing that information. So it's hard to know exactly what they're doing. But from the press releases, you can read about losses, and you fail to read about many cases brought. So cartel enforcement is generally considered to be down substantially. Civil Section 1, this would be, Sherman Act, the basic antitrust materials. If you go look at the Justice Department Antitrust Division in terms of enforcement actions, FTC, Justice and FTC, you'll see towards the right that again, that litigation by the agencies is down, not up. They talk a whole lot about being aggressive, but the number of cases brought is down. Now, I will say, you see my CF in the last little bit, the Justice Department has filed big deal cases, civil Section 1 against Ticketmaster Live Nation. And now they filed one recently against RealPage, which is using artificial intelligence and data to provide information to renters, landlords about rents. So those are big, important cases that have been brought, but in terms of the actual number of cases, they're down significantly. For mergers, let's go talk about mergers. There's been a lot of talk from the Biden people about how they're concerned about mergers. They make it clear they're not fans of mergers. But when you go look at what's actually happening, this is a chart put out by the Deckert Law Firm of what they call significant U.S. merger investigations concluded. This is mergers where there was government something, maybe a complaint, maybe an abandonment of the deal where they say the government was investigating it, so they abandoned the deal, or it is a lawsuit that is won, or it is a consent decree like that. Something the government has said this was a merger that was affected by government enforcement. And if you go look down at the bottom, the blue is the first quarter, the orange is the second quarter. You'll see that as a general matter, merger enforcement during the Biden administration is significantly lower than it was during previous administrations. This is the same information on a horizontal graph. Again, merger enforcement is down from where it was before. What's going on is revealed in this slide, which shows the outcomes of those same cases that we looked at. And in particular, look at that light blue. In 2016, there were 26. That's consent decrees. And it used to be, you can see from this thing, that there were lots of consent decrees. And so that would be what you did in the merging business. You notified a merger to the antitrust agencies. They would say, we are concerned about this because you have an overlap in this product, and you'd agree to spin off that product, enter a consent order, and go about your business. And as I told you, the Biden folks are very, very down on remedies, very down on consent decrees. And so there have been very, very, very few consent decrees. On the other hand, the dark blue is abandonments, where the parties say, we abandoned the deal totally and give up on it. And you can see that has gone up during the Biden administration. So it's much more of a take no prisoners. If we're concerned about this, we're going to litigate it to the death, but we're going to be concerned about far fewer mergers than our predecessor agencies were. So it's sort of a mixed signals, fewer challenges, but because of the aversion to consent decrees, more abandonments. What else can we talk about? Section 8, interlocking directorates. That's something that has become a focus of this, the Biden administration, in a way that it's more pronounced than for previous administrations. FTC competition rulemaking, the FTC announced, formally issued a rule that bans almost all non-compete clauses for significant companies and significant employees across the country. And that's totally changed because they used authority that had not been used since the Carter administration. It had been used there only once or twice, and had been approved in a DC Circuit case with J. Skelly Wright or David Bazelon, with an opinion that harkened back to the good old days when agencies got lots of deference and were allowed to sort of fill in ambiguities and proceed in a way that seemed to make sense. Well, so far, the FTC has met with mixed results in its case. The whole rulemaking has been declared unlawful by a district court in Texas and prohibited. That's now on appeal. It was okayed in another district court, so there's been some mixed results, but at the moment, the rulemaking has been halted, and we'll wait and see what the Fifth Circuit wants to do. But yes, is that different? That's very different. And then the biggest change is Section 2, monopoly. And remember I told you that there used to be good data on the Justice Department website? It ended in 2019, so that's why I have data through 2019. There were, in 20 years, 1 or 2 Justice Department monopoly cases. Total, 1 or 2 in the 20 years, 2000 to 2019. Nowadays, the top is the Justice Department, the bottom is the FTC. Many of these cases are brought with state enforcers who've become much more important in the last number of years. You've got cases against Google, 2 of them. The first one you got to make a note of was filed during the Trump administration, recently was successfully won in the district court in DC. We don't yet know the remedy. Apple, I told you about, like all those are monopoly cases, with a couple of them also being Section 1. The FTC case against Facebook, that was filed during the Trump administration. The other ones are new. Again, this level of monopoly, remember, 2 cases in 20 years, and all of those cases are pending today. That's a real sea change, completely different use of enforcement resources. Okay, how are we doing here on time? We're doing okay. And let's talk about how much of this will last. And first, we need to mention that the administrative state is under assault like never before in my lifetime. Those of you who take or practice administrative law know about this. Just case after case after case after case. The current Roberts Supreme Court has made clear that it is not keen on deferring to administrative agencies. The administrative state has become an epithet that especially Republicans toss around as a bad thing that is harmful. And they're just a large number of different cases where administrative agencies have lost. The Chevron cases came down in June. That was on the amount of deference to give government agencies, and the answer is give them less deference than you used to. The SEC case addressed the question about administrative law judges, which the FTC uses, and now there's more opposition to allowing law judges to be deciding important questions. The major questions doctrine, it's a way for the Supreme Court to say, this statute, you know, you might read it the way that the agency wants, but it's addressing a major question, and we insist on clarity, and there's not clarity, so therefore the agency loses. The Ohio v. EPA, an agency law saying its rulemaking was arbitrary and capricious, that will be used against the FTC in its effort to do a non-compete rule. Disgorgement as a remedy, you know, for a while there, the court was willing to imply a remedy so as to achieve a good result. Less keen on doing that, as suggested by that case. And then I just list in the last one, that little case where it's just one of the countless such cases going on, where it's a lawsuits against the NLRB, and the district court said the NLRB, as it's structured, is unconstitutional as to how its leaders get appointed, how its law judges get appointment. Every time the FTC now is in litigation, one of the defenses is that the Federal Trade Commission is unconstitutional, and it's just a different era where it's much harder. And yes, this backdrop matters for competition. The FTC managed to lose 2 cases in the Supreme Court, 9-0 in the last couple of years, on when there could be a challenge filed against it, and on whether or not a statute could be read to allow for disgorgement and consumer redress. And just so you can get the idea of the change, the AMG Capital Management, this was an FTC statute that had been interpreted by lower courts for, I don't know, 20, 25 years, saying that slightly vague wording allowed the FTC to order the disgorgement of illegally obtained gains. And I would say probably, 7 courts of appeals had sided for the FTC. No court of appeal sided against the FTC. It was the most brilliant job of lawyering over decades to develop this body of law. And finally, conservative lawyers got a case, this one, before the Seventh Circuit. And the Seventh Circuit said, well, we know every other court of appeal has read it in favor of the FTC, but we read the words and it doesn't seem to us that Congress meant for the FTC. It doesn't say FTC disgorgement and redress, so the FTC cannot do it. And up in the Supreme Court, even though all of those courts of appeals had sided with the FTC, 9-0, the FTC lost. And then I cite here the Texas case that has slapped down non-competition rulemaking. It's going to be a hard job for the FTC to get that reversed, because the Fifth Circuit is not the kind of place that seems likely to want to reverse it. And to be honest, the U.S. Supreme Court doesn't seem likely to be the kind of place that wants to reverse it. This was a big power grab that may not work. We'll see. Then the other thing that is important in terms of looking forward is Supreme Court antitrust cases. We've been talking about cases brought, cases litigated, procedures, and policies, and all that sort of stuff. But it all takes place in the backdrop of antitrust law. And antitrust law, because the statutes are so general, right? A contract combination, conspiracy, and restraint of trade is illegal. The statutes are so general that what the courts do really matters. And in the modern era, since 1976, when you go to the Supreme Court with a substantive antitrust case, 65% of the time, the defendants have won. And then I list a bunch of these cases, and those of you who know antitrust can see it's a greatest hits of Supreme Court antitrust cases, all won by defendants. And when they win, the court writes an opinion, and the Supreme Court opinions in antitrust cases are chock full of words that are music to the ears of defendants and defendants' counsel, right? So here we go in Amex, Justice Thomas, illegal presumptions rest on formalistic distinctions are disfavored. And he goes on, and it wasn't necessary to the opinion, but he writes that you can't apply a rule of reason without an accurate definition of the relevant market. Well, if you really mean that, what that means is that no plaintiff can bring a rule of reason case without hiring a fancy and very expensive economist. And so it's words that are written in that defendant win opinion that are very helpful to defense lawyers and to defendants. And he reminds people the importance of avoiding chilling the very conduct. The antitrust laws are designed to protect great words if you're a defendant. Another case, Linkline by the Chief Justice. As a general rule, businesses are free to choose the parties with whom they will deal, as well as the prices, terms, and conditions. Cutting prices in order to increase business is the very essence of competition. Clear rules, all of this is music to the ears of defendants. In the NCAA case, which was actually won by the plaintiffs, the Supreme Court unanimously, in an opinion by Justice Gorsuch, wrote very pro-defendant words, talking about, right there, the second bullet, the inherent limits on a court's ability to master an entire industry. Take special care not to deploy these condemnatory tools until we've amassed considerable experience. In other words, be careful about ruling for a plaintiff. More from that one towards the end there. Markets are often more effective than the heavy hand of judicial power when it comes to enhancing consumer welfare. Well, that's the backdrop. Consumer welfare is something that the Biden folks have condemned that term because it tends to focus antitrust on competition and prices and output. But the term consumer welfare appears in all of these Supreme Court cases. So the Biden folks may not like it, but there it is. Indeed, consumer welfare is in all of these cases as well. There it is. Other pro-defendant wordings. The idea of a false positive, which means make sure you don't rule too quickly for a plaintiff, that appears in, I did a search, this is about 4 months ago, in, 5,000 lower court opinions use the word false positive, make sure you don't rule for the plaintiff too quickly. You get the idea. So the bottom line, and we're getting towards the end and wrapping up in case there's a question, so that's good. Is that the future has just incredible uncertainty. Part of it is the administrative state cases, because it means that there's always the risk that the government is showing up in court and trying to get some deference for its interpretation of the Federal Trade Commission's wording, unfair methods of competition. And, there's nothing good going on in the administrative state line of cases if you are the Federal Trade Commission. The competition rulemaking, my guess is that if the FTC, if the Biden administration were to become the Harris administration, and the same people or people like them would be left in charge of the Federal Trade Commission. And if they were to win the competition rulemaking, the non-compete rulemaking, my guess is that they would then say, let's go try another kind of competition rulemaking, and on you go. But as I said, there's a very good chance that won't happen, because there's a very good chance that this effort will be defeated. I mentioned the pending cases. People sometimes talk about what would the next administration do. Well, go back to all of those cases. Where were they? Back up there in, right here. Well, I remind you that first case against Google, that was filed during the Trump administration, and we do not yet have what the court is going to order as a remedy. And the case against Facebook was filed during the Trump administration. And we don't yet have an answer to the thing. And all of those cases are going to keep on keeping on. So part of the uncertainty is simply what's going to happen. And the world could be very, very different, both in terms of doctrine and in terms of the economic realities of competition out there in these industries, depending on how those cases play out and how they're treated by the next administration, which is never totally known. Go back to the guidelines. I showed you how very different they are from previous guidelines. Well, the big question is what will happen to them in court. The merger guidelines as an enterprise since 1982 have been astonishingly successful. This document that Bill Baxter, Assistant Attorney General, helped create, in which he just said this is just an internal document, how we think about mergers. It has become the guidelines, and the revised guidelines before the current revision have been cited by scores of cases as good statements of the law, as a useful reference point for what merger law is. They have been treated almost as though they're a Supreme Court opinion. It's been phenomenal success. And the question is whether the new guidelines, which look so very different than all of their predecessors, which sound so very different than all of their predecessors, which very much have the feel of an amicus brief, will they be treated like an amicus brief as just one more offering from the government, or will they get the same kind of amazing deference that predecessor guidelines have received? And that will make a big difference. And then last, we come into the November elections. And there I want to remind you that J.D. Vance has famously announced that Lena Khan, the very, very well-known, celebrated or disliked, depending upon your point of view, chair of the Federal Trade Commission, he said she was doing a good job. So who knows how all that will play out. In terms of the elections, I mean, you know, in the normal course, you would have turnover in those agencies. Just because the length of term for an assistant attorney general has already been exceeded by AAG Cantor, and for a chair by Chair Khan. And so I would, if the norms were to be followed, you would see those people stepping down this fall, either right after or just before the elections. And then we'd get new leadership. And we're not sure where that will go. Back when the FTC won, I'm sorry, the Justice Department won its Microsoft case, the last big, great monopoly win, the administration's changed and the new administration settled it for a settlement that some people thought was not nearly strong enough. And so the new administration is the new administration. And there will be a new administration no matter what. And President Harris could change the AAG and the FTC chair on day one. So we don't know what'll happen, but it's a wonderfully fascinating time. And so I'm just thrilled that all of you were willing to join me. The last slide here tells you the bottom line, which is that don't look for massive changes because of the courts. Do look for a lot of state enforcement and private enforcement because that's been occurring at a record pace and I don't see it slowing down. You know about the midstream and then parts of the Biden administration. That agenda, part of it will endure. The whole of government approach, I think that's been a success and people have said we ought to be thinking about competition in the Department of Agriculture and the Department of Transportation and such. Interlocking directorates, again, I think that will continue to be a concern because why not? We ought to be worried when people are directors of competing companies. The algorithmic coordination involving, it's happened now, there have been cases involving agricultural products and rents. You know, that's a big deal and it makes a big difference. And I'm guessing that will continue under the new administration, whoever it is. Some of the private equity concerns, I think, have sort of got legs and will be there. So some of the specific things will remain, but the general approach, you know, it's very hard to predict that. What I can say is that this different climate, I think that will remain. And this climate that we have seen, the warming of the atmosphere, the warming of antitrust, I think that will continue on and be affecting scholarship, enforcement, and indirectly, at least, the courts. Thank you very much. A pleasure being with you. And we have a little time left for questions, but it's my pleasure. And thank you for your patience and listening.
Great. Thank you, Professor Calkins. I'll start with a couple questions that we have received either in the chat or in the registration process. But this one is a good first question. I'll read it now. What good case law would you recommend that would support a way around / defense to per se illegal antitrust practices?
Well, I would say two things. One, go back to that list of defense win Supreme Court cases and some of those quotes of pro-defendant wording and pull them out and feel good about yourself. And then more specifically, I would look at a case called the United States versus Brubaker. Remember I said that the Justice Department has lost criminal price fixing cases? Well, here's one where they lost a criminal price fixing case. It was one where there was coordination on a government contract and they sort of caught them dead to rights conspiring to agree not to compete. And if you look at it, it looks very much like this is criminal and illegal per se. But the lawyers for the defendants said, no, 1 of the companies was a supplier to the other company. And so although they did submit competing bids without as much competition as maybe they should have, and indeed, I think they were found liable for fraud or something like that, the court said that because it was a supplier and a purchaser, they were a vertical relationship, and vertical relationships are almost always rule of reason, and so therefore the defendant wins, and this per se win is tossed out. And I would look at that case as a exhibit A on how to take what looks to be per se and say, no, it should be rule of reason, with the caveat being that the Solicitor General has asked the Supreme Court to weigh in on the case. So either it's going to be endorsed by the court or tossed out or something. But for right now, it's a poster child of how to take something that looks per se and characterize it such that it ends up being treated as the rule of reason.
Great. We also received now 2 questions that relate to antitrust within sort of the healthcare realm. So I guess I'll start with this one, is wondering if you have any thoughts or comments on the recent acquisition of Ascension Health by Henry Ford and the antitrust implications that may be involved.
Do I have any reaction? I have a couple of reactions. First, I have not studied the data, and so I don't have a sophisticated view. That's one. Second, if you were to make a list of mistakes made by enforcers over the last 20, 25 years, high on the list would be failure to challenge hospital mergers that have lessened competition. And I think there's some pretty good evidence that if you have too much concentration in hospitals, that's going to lessen competition and result in higher prices. And I know that it's a concern to the enforcers. Now, having said that, I know it's a concern because the FTC did bring one case and ended up well, it was a mixed outcome, but the one is they brought a case. So there is some concern there. In terms of this particular one, I'm just a layperson here who sort of says, gosh, there are a number of hospital systems, and is this going to put it over the threshold and say there are too few? And, it's a great question, but I don't know the facts well enough. If it is, then it's a matter of great concern. But there are so many hospital mergers going on all the time, and you saw the numbers of how few merger challenges actually get filed, and you also know that the Justice Department and the FTC are putting huge resources into other matters. So in a way, it seems to me a pretty good time, if you're the merging companies, to be trying to get a deal through without getting a challenge. But clearly, these are big companies. Clearly, it's going to increase concentration. Whether it's enough of a concern that there will be a challenge, I'm afraid I don't know the facts well enough to have an informed opinion.
Okay. Awesome. Thank you so much. Another question that came.
I didn't know anything. That's okay.
It's okay. Something to do in your spare time, I guess. And another question that came in while you were talking, I'm going to read it. It's a little hefty, and if we can't get to it or you need more information, then I'd be more than happy to connect you and our alum. It says, Professor Calkins, you described that the recent merger guidelines deviated from previous ones with respect to the administration's focus, market power versus democracy/society. I've always thought that this change in the guidelines as the Biden administration, I always thought of this change in the guidelines as the Biden administration illustrating the effect of market power dominance, for example, big tech and its influence on social and political climate. Having in mind the current administration's focus on past mistakes, do you think the current administration is too trigger happy with antitrust enforcement, Or was antitrust just under-enforced for the past few decades?
Well, first off, trigger happy. The current administration, in my view, is not that trigger happy because the number of cases they're filing is down from previous administrations. And usually when you say trigger happy, you say filing more. What is different is the willingness to take on those big monopoly cases. And on that one, one of the fact patterns that people bring up sometime is what about Facebook and Instagram and Facebook and WhatsApp? Should those mergers have been challenged? And when you talk to people who were paying attention at the time, they say that, if I look at those, whatever they're called, products today, I say, talk about head-to-head competition. You certainly would not want to have a merger between Instagram and Facebook. That's a no-brainer. Clearly, it ought to be illegal. But I am told by people who were paying attention back at the time, note, I'm not saying I have personal information, and they say that at the time, Instagram was this tiny, tiny little, almost, a couple of people in a garage kind of business. And yes, today it is a major competitor. At the time, if you were really smart and knew how tech works and things, would you have been able to figure out that this should be illegal? And would you have been able to persuade courts to do that? And I'm told that it is not as easy as you think it is, because we look at that and we say it must be illegal, okay? And yet I'm told that it was much harder. In terms of bringing big monopoly cases, I think the example people trot out would be the FTC thinking about bringing a monopoly case against Google back during the Obama administration. And on that one, there was certainly a substantial case made saying that Google ought to be challenged back then. And so, can I be sure that that's right? No, but there's a significant argument that the FTC got it wrong when it decided not to challenge Google. It was a close call by a divided commission. And so maybe they made a mistake on that one. And so you could say, yes, probably they didn't. And people didn't appreciate big tech and how it works and the staying power and the importance of data. And it took a while to learn that. So yeah, were things done that were less than ideal? I think probably so. On the other hand, these are decisions made in general by good people who are trying to do the right things, and they're hard calls. But sure, I think you could say there should have been more enforcement. But I want to remind you that the Facebook Instagram case was filed during the Trump administration, and the Google case that was just one was filed during the Trump administration. So I think that antitrust enforcers in general have become more concerned about big data and the tech companies, not on a partisan basis, but on a bipartisan basis. And the first return on the Google case was a win for the government. My guess is that's probably a correct outcome, and it ought to be affirmed, and it probably will be affirmed. But with respect to all these other cases, I don't know if the rest of them are going to have uniform success. We'll just have to wait and see. The courts are very conservative, and it's not easy to win these cases. So I don't think you can be confident that the big monopoly cases, which is where the change is, are all going to be won by the government.
All right. Well, we are pretty much at time right now. So I want to echo just what I've seen over the chat, as well as kind of what Rob has said already. But thank you so much for taking time out of your teaching schedule, Professor Calkins. It means a lot, and we're just so thrilled that you could share your expertise with us on this call today. Yeah, and we will be sending out more legal briefs, announcements, and other programs that folks can join. But Professor Calkins, if you have any other last sort of remarks or anything to launch people into the rest of their afternoon, you're welcome to do that. And if not, we can end our time together.
Well, I would just say that by all means, you should be heading down to the symphony and supporting culture in Detroit and in Southeast Michigan. And if you know of any law students, you should encourage them to get a sound card. And you should be pleased at all the exciting things going on in Detroit and at the Wayne State Law School, where things are moving along, and it's an exciting time, and we're glad to have people interested in what's going on in Detroit and at Wayne Law. And I guess the other thing I would say would be that you're allowed to cheer for the Lions too, because that's part of Detroit.
I agree with all of the above. But anyways, thank you everybody for joining us. And we look forward to seeing you at future events, whether it is here online or somewhere within our community. So thanks.